Right. Good evening. Good evening, class. We are now at the second last lesson, and our last lesson has been rescheduled to 19th of January. That is next Tuesday. I hope you have received the notification, haven't you? Were you able to hear me? I was asking if you have received notification for the last lesson, or rather, yeah, for our next lesson rather, because we didn't have our scheduled lesson on the 12th, and it's now been rescheduled to. Thank you. So you have got it. That's very good. And right. Now, I've got the figure. I've got 28 of you signed on. Maybe there may be others coming on pretty soon. So maybe we use this opportunity to see if you might have any questions. Did you hear the news about the Court of Appeals judgment over the small house policy? Yes, and that's a recent example of a judicial review proceedings in which government's policy was being reviewed on whether it contravenes the basic law, and the provision in the basic law is Article 40, under which lawful rights of new territories residents and inhabitants are being protected. And the question was whether the rights arising from the small house policy, or rights protected, meant to be protected under the small house policy, whether it would contravene the basic law. And that is an example of what we generally classify as a constitutional review. And we're going to get to that later on. We'll have a little bit said about it later, although we have already, of course, done our judicial review, but as far as a constitutional review is concerned, we could say a little bit more about that later. Okay. Well, last time we were on this proportionality test. I mentioned about the traditional, it was initially applied as a no more than necessary test, and where after identifying the legitimate purpose of a certain policy or action, the court will look at the impairment or the restriction imposed, whether it meets this what we call the no more than necessary test. In principle, in terms of concept, the court will consider the size of the restriction, i.e. how much or how restrictive that might be, and whether is too big a restriction or too large a restriction. So the question asked is often this, i.e. is the restriction no more than necessary for achieving the legitimate purpose, i.e. whether it is a minimum restriction. And this is what we sometimes call the minimum impairment test. Minimal impairment test. A case for illustration, and for answering these questions, we often say these are fact-specific questions. It really depends on the facts of each case, and the court, and because it's judicial review, the facts are normally uncontentious. They are not of serious dispute, and it is on that basis that the court will perform the weighing exercise. If the facts were in dispute, in great dispute, then the action it may be a case more suitable for a general for a common law action. So the case of Ng Kong Siu is one which concerns the constitutionality, whether national flag and national emblem ordinance, which bans the desecration of national flag, is a lawful restriction on freedom of expression. Desecration is just another word, generally means damaging. So we have facts like burning the flag, or even where we had cases where the national flag was being thrown into the seawater, or just being torn. Now, of course, people might be charged for that conduct, and if they raise the defense that by damaging the national flag, it was a means that they chose to express a certain message, then we say that the Basic Law provision and the Hong Kong Bill of Rights Ordinance provision on protecting freedom of expression is being engaged. That's the word, engaged. Now, once a provision of that nature is being engaged, the court will hold a proportionality test. And in that case, the Court of Final Appeal did find the restriction acceptable and had passed the proportionality test. And the question posed for you to think is, why is this a small restriction? Why isn't there a lesser restriction that can achieve the same purpose? Now, first of all, you may ask, and I would like to ask you, what actually is the legitimate purpose that you think this ordinance was intended to achieve? what would be how you would frame that legitimate purpose? Protecting the integrity of the country. Mm-hmm. Any other suggestions? Mm-hmm. Well, it was considered by the court that a flag is the symbol of the sovereignty, and which has to be protected, and that there are other means, other ways of expressing their the defendant, 公诉, in this case, their views about the country, about PRC, and therefore it passed the test. Yes. And indeed, in the judgment, the court held that this was an important symbol of the People's Republic of China and Hong Kong SAR, and and because of the societal and community interests that were involved, that the court considered it was the restriction, i.e., the desecration, was had passed the nationality, had passed the minimum impairment test. So this case was decided in 1999, and it had set a very important principles. It says that this restriction, i.e. the criminal offense created, bans only one mode of expressing whatever the message the person concerned may wish to express. That is, the mode of desecrating the flags. It does not interfere with the person's freedom to express the same message by other modes. So there is the alternative or the other means of expression, which the court consider therefore is not, it passed the minimum impairment test. There is the other case, 10 years later, Chen Ginsam and that concerned the banning of prisoners from voting. That was considered, the right to vote was considered as a political right of such importance that short of practical impossibility, public resources should be committed to enable prisoners, people in the custody, to cast their votes during the time when they are in prison. And this after this decision, the court, the government brought amendment to the law, and now, of course, prisoners, even if they are in custody, they are given, arrangements will be made so that they can cast the vote same as any other registered voters. I think this one is fairly easy to understand. The quotation is the useful quotation is before you. It says that this is what the court has said. I have come to the view that the general, automatic, and indiscriminate restriction on the right to vote and the right to register as an elector cannot be justified under the Proportionality Test. I must strongly emphasize that the court is not suggesting that some form of restriction on voting or even registration cannot be imposed by the legislature against those in jail and others. When you go to look at this judgment, you find that the court, on the facts of the case, it was illustrated to the court that there were some, if you like, absurd situation where a person who may just be kept in custody for a very short period of time, and yet they are deprived of this such important political right in the same extent as a prisoner who probably is sentenced to life imprisonment. Now, that on the face of it seemed not to be just. You may very well argue that, well, a person who had committed a very serious offense, therefore it didn't sound offensive to take away their right to vote. But what about a person who is who has been convicted of far less serious crime? Then what? So this, I think did not find favor with the court. And again, this actually, you may see that the courts, when examining any government, the constitutionality of any government measures which have the effect of taking away or restricting fundamental rights of citizens, they will they do not favor seeing a policy, a decision which cuts across the board, i.e., make it apply to everybody, strict jacketing that, and providing no exemptions, providing no exceptions. Now that is something which it will be very difficult to justify. So that is one thing that we could learn. And of course, when you look at it from a more human point of view, rather than treating this as law, to do something without considering or to make a decision of doing something without catering for exceptions may not be a very good idea, because things in reality, in real life, for things to be exactly the same, that perhaps is more remote than a situation where there must be some exceptions that therefore for a decision maker, they should think about, give it more thoughts, and provide some reasonable grounds for either applying for exemption or being accepted altogether. So what is a big restriction, or what is a small exception or restriction? That, in a way, there's no scientific really formula. We have to look at the cases, and like, for example, under the National Anthem law, now of course we have the National Anthem Ordinance, and there are these restrictions which now become an offense in the Hong Kong Ordinance. These obviously would be regarded as restrictions on freedom of expression. I gave you a picture of spectators at a football match. Now they on this one they were displaying a Hong Kong independence banner, and would that, and also, and of course, assuming that it was at the time when the national anthem was being played, and under the law you will have to stand and pay respect and be respectful to the playing of national anthem. But the pictures show that I think you can show from the expression, the facial expressions, that they were acting to the contrary. Now, assuming that they were also, singing something which could be classified as derogatory, then that may constitute an offense. And would you consider this as small or big restrictions? And will they pass the proportionality test? Now, I'm putting this to you for you to think, and I'm not proposing to give you an answer, but that is what I call, well, let's say, fact specific. Fact specific. You will have to look at it about you have to the formula or the tests is clear, and it's then becomes a matter of application, how you apply the test. With the two-part test, proportionality test, it's being developed by the court, where to illustrate that during this application, when I say fact specific, they actually also went further and discussing categorizing impingement of rights into what is called the tougher, into different degrees, or I beg pardon, the nature of the rights, and therefore applying different level of tests. So the normal test, the normal way of describing the test is as minimum impairment test. Then it is in effect applying the so-called no more than necessary test, i.e. whether there are alternatives which are less restrictive. And the court went on to say, well, but if the rights being engaged are fundamental rights, these rights such as rights against discrimination, then the court will apply what is called the intense scrutiny test. Intense scrutiny test. In effect, it's less easy to pass the test. So it's a case of giving more weight to the right being alleged to be restricted. If it was a case that does not engage fundamental rights, such as governmental spending, such as, remember the case that I referred to about the lady who married a gentleman who died quite very soon, in 2 years after the lady came to Hong Kong, and she was application for Social Security was rejected because she did not meet the 7-year residence requirement. Now that is a case that concerned government spending, and the court applies what they call the no reasonable justification test, i.e., the court, as long as the court considered that there was justification which is reasonable for that sort of policy, it will pass the test, right? So in a way, it's sort of a way more in favor of government if a case did not engage fundamental rights. With this two-part test, it moved on into developing a four-part proportionality test. The seminal case, the authority on this is Hysan Development against Town Planning Board. Interestingly, this is not a human rights case as such, and as you can see from the name of the case, it actually involved the restriction of development rights of a property developer, Hysan. And the challenge was whether the imposition of some building restrictions, which resulted in the developer not able to obtain the maximum benefit economically from developing the land. And what was engaged was the property right rather than fundamental rights. And that, of course, is interesting, of course, but what is important from this case is the how the Court of Final Appeal had revisited or reviewed the applicable tests when conducting the constitutional review of certain government policies. And it developed what we later on call four-part test. In actual fact, is a series of tests developed or evolved from the conventional, the orthodox two-part test. The first question is the same question that's asked: does the restriction have a legitimate purpose? Does the restriction have a legitimate purpose? And was it therefore change it to other expression is it really necessary? Is it a test? Is it something that has to be done? I told you that on the anti-mass law judicial review, there was no disagreement between parties that there was a legitimate aim, legitimate purpose for making the anti-mass law, because it was agreed and there was expert evidence that the wearing of mask does embolden the wearer into doing something that he or she would not normally do, and that could become a catalyst, or rather, that may become a means to encourage people from acting violently or supporting violence, and therefore there should be law restricting the freedom to choose what to wear. Right? And of course, because the anti-mask law also or target this kind of behavior at times of public assembly and public procession, which are rights, fundamental rights protected both in by the Basic Law and the Hong Kong Bill of Rights Ordinance. And the wearing of mask was also considered as rationally connected with the legitimate purpose. The legitimate purpose, of course, is the keeping law and order, maintaining law and order, and preventing violence. Is the restriction no more than necessary for legitimate purpose? Are there any other means for achieving the same? In the anti-mask law, the restriction to wear masks apply to both lawful and unlawful public assemblies and public processions. In the court of first instance, those restrictions, the only restriction that passed this test was the restriction against unlawful assemblies and unlawful processions. If the unlawful assembly or procession was lawful with no breaches of conditions, those restrictions were considered not more than necessary. Were considered more than necessary for achieving the legitimate purpose. In the Court of Appeal, it did not agree with the Court of First Instance, and as long as decided that the restrictions only if they are not lawful initially, then people should be free to wear their mask. The other provision, which is actually Section 5 of the Prohibition Against Face Covering regulation, which is not restricting people to wear masks, but it is an empowering provision which empowers police officers to ask people who are wearing a mask at a public place to remove the mask for the purpose of identification. And they make it a crime if you refuse to remove the mask upon the demand of a police officer, unless you have got lawful authority or reasonable excuse. That itself was also found not no more than it doesn't meet the third test. Court of Appeal also was in agreement with the Court of Final Appeal, Court of First Instance. Now you should notice that government, when the case went to Court of Final Appeal, government did not appeal against that. Did not appeal against that at all. So it remains a piece of that part of the legislation remains not effective, not having the force of law as of now, and for good. Court of Final Appeal did not agree with the appeal court, and indeed uphold all the restrictions that apply to both lawful assembly, both unlawful and lawful assemblies and possessions. In the judgment, actually, the court is quite a good illustration that it's not absolutely necessary to go to the Part 4 test, but even if it did, the court need not dwell into it too much, because the court has said, even in Hyson, that if a restriction is able to meet the 3rd part test, it normally would meet the 4th part test. But just in case, this is reminding the judge that ultimately, at the end of the day, you should look at the overall picture again, and stepping one step backwards, and see whether the comparing the benefits of the restriction to society and the detriment it may bring to individuals, and see whether a reasonable balance has been struck. Would it be such a big benefit that worth the detriment caused to the individual? Would it be an overkill? Would it be using a hammer to crack a nut? So there has to be a reasonable balance, right? So that is a four-part test developed or pronounced by the case of Hyson. This seemed to be complicated. Well, maybe many of you did not find so. In any event, we are saying that don't panic. It seemed to be complicated, but what we would expect, what we hope you can achieve, is to at least understand them, and for the purpose of your assignment, actually, you will have to make reference to these in explaining how the courts under Article 39(2) develop principles for protecting the rights that are referred to in ICCPR as set out as provided in Article 39(1) of the Basic Law. Right. Are there any questions up to this point? Yes. Okay. Now, right. I'm going to start the topic of interpretation and amendment, which is going to be our last topic, and we are going to go through the materials provided in Chapter 7 of our manual. Chapter 7, and here we are intending to explain to you the system of amendment in Article 159 of the Hong Kong Basic Law, and why it is so rarely used, and explain the system of interpretation in Article 159 and the problem that these interpretations may cause. And there are a couple of judicial cases which are set out on page 74 of your manual that you should at least you should be aware of, and take time to read the extracts that we have provided in the manual for you, and be able to identify the principle, the general principle that were decided by these cases. So these are the most important one, of course, is Garling, and then we have Lau Gong Yong, and then Zhong Feng Yun, and then what I just normally call the Congo case, the Congo case. Yeah, but Garling will be the one you must know. And since and also all the interpretations are, of course, important, but the most recent one, interpretation by the Standing Committee of National People's Congress, was on Article 104. 104. 104 is the requirement in the Basic Law that the Chief Executive, Executive Council, councillors, members of Executive Council, judges, and the members of Legislative Council, when they take office, when they assume office, they have to take an oath of allegiance. And we had this interpretation made by the Standing Committee back on 7th November 2016. I'll make reference to the facts of that, or the background to that interpretation later on when we get to the point. So first of all, let's get some concepts right. Let's get some concepts first, and that may be easier for us to understand, have a deeper understanding of the basic law mechanism and how it had been applied so far. Under the common law, there is a distinction between amendment and interpretation. The biggest difference is that amendments are, first of all, amendment is a law-making, is law-making. And because it's law-making, it can only be made by a body that has the power to make law. And the making of law in amendment is by supplementing a law by adding new words. You can also take it further by this amendment can by way of omitting, or by removing certain existing words. So we are talking about a textual exercise, an exercise directing at the texts or the words used in the law, the written law, and that is called amendment in our common law concept, common law legal system. And interpretation is different. once a law is made by a body which has the power to make law, then when it comes to application or implementation, it will be for the person or the body applying the law, either as a law enforcement agent or indeed a court of law when resolving disputes, when adjudicating cases. They, by nature, it is clarifying the existing words of a law, clarifying the meaning of this. And it is case specific. It is in the course of acting on a particular case, either in court or outside of court in the case of the law enforcement agencies. They must, any words are meant to bear meanings. Sometimes you may think that, you may say, oh, it's so clear, it doesn't need interpretation at all. Yes, that's because the words used are so clear that the interpretation process will be simple. Because the next step will be a matter of application of the meaning to a particular factual scenario. Sometimes words used, either because for whatever reason, are deliberately vague or obscure, or the expression is doesn't bring out only one meaning but more than one meaning, then it will need some exercise of judgment, following certain rules on the meaning of it, of the provision, and that exercise, that process, we call it interpretation. In the common law system, interpretation let me put it the other way. Once a law has been made by a lawmaking body, then the lawmaking body will not have the right to interpret the law that they made and give further meaning to the words that they had used. If they wanted to do that, to add further meaning or clarify certain matter, it will be another lawmaking exercise of amending the law. It is so we have to understand this the fundamental system in common law. If the interpretation given to the same provision by different parties vary, they are not the same, and led to some dispute which which lead the parties to court. Only the court can resolve this dispute. Sometimes it is in the course of litigation, in the course of a criminal trial, that the court had to put a meaning to the words. I make reference to the interpretation given by the Standing Committee in 2016, November 2016. Remember, that is an interpretation given by the Standing Committee of National People's Congress. It is not an interpretation given under the common law system in Hong Kong. At the time when the interpretation was given, November the 7th, 2016, there was actually a court case being adjudicated in court. There was a case initiated by the Chief Executive and the Secretary for Justice. Applying for judicial review of the lawfulness of the President of Legislative Council decision, allowing Sixtus Leung and Yao Weijing to take the Legislative Council the second time, after they had adopted certain manner which was later on described by the court as unsincere and also not unrespectful, and therefore not meeting the standard required by law. Now, it was against that factual situation that the case went to the Court of First Instance. The court had to interpret certain provisions in the Oaths and Declaration Ordinance in Hong Kong on whether the conduct or behavior of the two persons constitute a denial or neglect in taking oath. And if the court should found that their manner of taking oath constituted that, then according to that law, they have to vacate the office of legislative councillor immediately. And the court actually could have a power to impose an injunction against their trying to perform the functions of a legislative councillor. So the court in that case also was also interpreting the law, but it is not the basic law, but the common law, but the written statute in Hong Kong, the Oaths and Declarations Ordinance. So that's the common law system of amendment and interpretation. And of course, an interpretation by a lower court could be considered as wrong. A party to that case may appeal to a higher court, Court of Appeal, or if necessary to Court of Final Appeal for the most authoritative interpretation. Under the Chinese system, under the Chinese legal system, these amendments and interpretation have much smaller differences. Amendment is considered as the formal process of supplementing a law by adding new words. In actual fact, that is very similar to our understanding in common law system. However, the biggest difference lies with our understanding of the process of the power and process of interpretation. By way of interpretation, the body that possesses the power to interpret may exercise that power to clarify the meaning of existing words of a law, to clarify, or adopting interpretation as a quicker method to supplement a law by adding new words. Now that is conceptual. So when under the Chinese legal system, when you are on the mainland, the word interpretation, in fact, bears a meaning very close to amendment, only that it is quicker, simpler in terms of procedure. Understand? Any questions arising from these two basic concepts? right? Amending the Basic Law. Under the Basic Law, under Article 159, it provides a mechanism for amending the Basic Law. Well, the Hong Kong Basic Law is actually by nature and by the procedure that it was passed, is a basic law made by the National People's Congress, as you can see the picture there, which has effect all over every part in the country. It is a piece of national law. And 159 makes it difficult. How? If you turn to that article, 159, and we can read that together. It says, the power of amendment of this law shall be vested in the National People's Congress. So what made it difficult under 1591 is the NPC normally only hold their meetings once a year. So if you miss that, you have to wait for another 12 months. The second paragraph, 159, it says, the power to propose bills for amendments to this law, the Basic Law, shall be vested in the Standing Committee of the National People's Congress, the State Council, and the Hong Kong Special Administrative Region. So only 3 proposers. It's not any member of the National People's Congress, and the bill should be proposed by the name of an institution: the Standing Committee, the State Council, and Hong Kong Special Administrative Region. So a bill has to be proposed, and it further on to say, amendment bills from the Hong Kong Special Administrative Region shall be submitted to the National People's Congress by the delegation of the region to the National People's Congress after obtaining the consent of 2/3 of the deputies of the region to the National People's Congress, 2/3 of all members of the Legislative Council of the region, and the Chief Executive of the region. Procedurally, it requires the clearance by the NPC deputies from Hong Kong, 2/3 legislative members, and the CE. So very stringent requirements. And then the next paragraph, it says, before a bill for amendment to this basic law, the Basic Law, is put on the agenda of National People's Congress, the Committee for the Basic Law of the Hong Kong Special Administrative Region shall study it and submit its views. No amendment to this law shall contravene the established basic policies of the People's Republic of China regarding Hong Kong. So in terms of procedure, unless it's from the State Council or the State Standing Committee of NPC, it requires the passage of motion with 2/3 majority of legislative members, and also 2/3 majority of the deputies to National People's Congress. That is where it says it's not easy. And what make it even less easy is no amendment to this law, the Basic Law, shall contravene the established basic policies of the People's Republic of China regarding Hong Kong. The question I have immediately is, where can we find those established basic policies of PRC regarding Hong Kong? So that, if you wanted to do any amendment, you also have to, there is also a limit, and it cannot contravene the established policy. But where are those established policy can be found? Joint declaration, yes. Which part of the joint declaration? All of you have got a copy, or you can take a look at a copy of joint declarations, and you will find the reference to basic policy. If you go to page 13, or in the version of the manual that I have, actually it is the appendix which contains extracts from the joint declaration. And paragraph 3 of the main text says in the following terms. It says, the government of the People's Republic of China declares that the basic policies of the People's Republic of China regarding Hong Kong are as follows. So they are set out in 12 smaller paragraphs, about 12 points, and that is commonly referred to as the basic policies. But when you get to 12, it says, the above stated basic policies of the People's Republic of China regarding Hong Kong, and the elaboration of them in Annex 1. So you have to go to Annex 1 and to include all those points as part of the basic policies, over Hong Kong, right, regarding Hong Kong. Got it? That's correct. Okay. There is, in addition, of course, I just read the requirement of consulting the Committee for Basic Law. All right. No amendments so far. No amendments so far. When you look at Article 151 itself, actually, is provides or makes clear that the power of interpreting the basic law is with the Standing Committee of the National People's Congress. I must add, and I had referred you to this before, that even without Article 158(1), it is under the Constitution, the Standing Committee enjoys the power to interpret the law, and that is in Articles, I think it's Article 67. The Standing Committee holds meetings every 2 months, and of course, in addition to these regular meetings, they can hold extraordinary meetings as short notices. And as far as interpretation power is concerned, and also the interpretation power as given by the Basic Law is concerned, there are no direct restrictions on those interpretations. For the restrictions as interpreted to contravene the Basic Law. I mean to contravene the Joint Declaration. So interpretation is a quicker and easier way for major issues. Issues here suggest that there are competing interpretations, or interpretations that are fundamentally different, and if an authoritative body like here, you may want to take it not necessarily to court, but to excuse me, to a more authoritative body. So that is in the what is the source of authority and mechanism under the Chinese legal system, and also the extension of that to Hong Kong via the Hong Kong Basic Law, right? That the power of amendment, or a power of interpretation, is recognized as quicker and easier for major issues. Going through the case, or the critical points of fact that gave rise to the later court case, and also the interpretation. It was in October 2016, pro-independence legislators used insulting language and behavior while they were taking the oath of office. And in November 2016, the National People's Congress Standing Committee issued an interpretation of Article 104 on oath-taking. As a matter of fact, there were 68 words in the original text of Article 104, and with the interpretation, which contains new issues for advice, the original text is 70 words, right? And when you look at the interpretation, there are 813 words. Let me see if I can retrieve that very quickly. Yes, you're quite right. And I just thought it might be easier if I put it on. Can you see this share screen? And here, of course, there is the original text, which is being published alongside the English, which is a translation. Can you see that? Because I was looking at the words there. When it was say 813 words, I can't remember whether we are making reference to Chinese words, but it's a pretty long explanation, interpretation, right? It started with a preamble, which sets out the background and the provision that is being interpreted, that has been interpreted by the standing committee, and then you see the points, the specific points. Point 1, paragraph 1, paragraph 2, and then under paragraph 2 there are a few subparagraphs. And now you must be careful. This interpretation is interpretation of Article 104, and it is not directed specifically to the case which was before the court at the time. Right? This is for that, obviously, in terms of time sequence, because any of these interpretation is binding on a court, therefore it will apply. It did apply to the case that is being considered but being tried by the court of first instance. Yeah. So and for future cases, this also becomes part of the basic law under Article 104. Right. So that is the importance of it, and this is quite, the way that it was interpreted, it was set out, was quite different from let me see, there was another one which was really very cryptic, really precise, if you like. I think it's 2, 4. Can you see this one? And you see the phrase, it was in 2004, it was interpreting the phrase subsequent to the year 2007, and after 2007 stipulated in the 2 annexes mentioned above, and the interpretation is include the year 2007. Include the year 2007. Now this is I think much easier to understand. Oh yes, interpretation is to give specific meaning, because the Chinese is the way it's expressed could, for some people, in fact give rise to ambiguity. When it says 2007年以後, whether it should include that year referred to. In modern Chinese writing, that is ambiguous. Of course, in traditional Chinese, more often than not is considered as inclusive of the year mentioned. But in today's Chinese, there is this word ham, which means include, and then giving rise to less ambiguity. Right. So let's go back to the to this slides that we have. That was the background to the interpretation that was rendered in the 2016 November. Now the question was considered by the Court of Appeal as well, and the appellants, the two legislators, of course through their lawyers, argue that the interpretation rendered was not an interpretation, but an amendment. Under the common law system. The appellants had also tried to introduce expert evidence to demonstrate that within the Chinese legal system, the way Article 104 was said to be interpreted was actually an amendment. However, the expert that they had engaged did not really say so in such specific terms. And the Court of Appeal actually held or decided against the two legislators, or the two then of the disqualified legislators, from introducing the expert evidence. The court made it clear that interpretation under Article 158 of the Basic Law is not the kind of interpretation we are used to understand in the common law system. It is a legislative interpretation which, according to Chinese legal system, the interpretation can clarify, just the same way as we do here in common law, or supplement laws. This point was later on confirmed by the appeal committee of the Court of Final Appeal. The case did not have leave from the appeal committee for the case to be considered by the full Court of Final Appeal. The full Court of Final Appeal will be, there will be 5 judges. Appeal committee usually 3, and on this occasion 3 judges. And the Chief Justice usually sits on all this, on appeal committee and the full court, of course. And here we should be very recognize that the difference lies with the two systems that Article 31 of the PRC Constitution allows. And as long as the interpretation was made within the Chinese law, then it will be given recognition by the courts in Hong Kong to have the necessary legal effect. And just trying to go back a little bit as to and to continue elaborating on the differences between the two systems, and because of that, the courts in Hong Kong now have made it very clear that these interpretations are binding on them, on the judges here. In the common law system, courts clarify laws, and they try to avoid making major supplements to laws. Because supplementing laws is part of the law-making process. And under the common law, and with the separation of powers as its cornerstone, the law-making job should belong to the legislature and not the courts. And not the courts. The reference to separation of powers in this context is to give recognition to the fundamental functions, to the functions given to these 3 bodies in the the governance of Hong Kong or of a common law system. And these three bodies, which may bear different names, but performing functions of a executive or legislative body or judicial body. So in Hong Kong, you have this chief executive and the rest of the government occupying the executive's pie on our chart, and the Legislative Council being the only legislature in Hong Kong, and under Article 73 is given the power and function to make law in accordance with the Basic Law and legislative procedures. The making of law includes the repeal or amendment of law. Judicial body, it is exercised by the courts, by judges sitting in courts and retaining the functions they've been performing prior to 1997, and such operation involved the interaction of these three bodies and having the effect of providing checks and balances. So that's the common law system, basically again emphasizing that each body plays its own part. And for interpretation, that power lies with the judiciary. And rules and doctrines have been developed through case law. And you should remember from your Hong Kong legal system that you learn, there are the rules, the literal rule, the golden rule, the mischief rule, and nowadays the purposive rule, which the courts have developed and generally apply or follow when interpreting local ordinances. And in relation to the Basic Law, under Article 1582, courts in Hong Kong are also authorized to interpret the Basic Law in areas that fall within the high degree of autonomy. When they exercise this function, they will apply these rules put out on the slide, asking you or telling you that there were differences between the four rules, but one thing that they are the same. But one thing is the same. What is the thing? I think this is something that you should have learned, all right, from your Hong Kong legal system. You learn that at your, when you said now, or have you done the subject Hong Kong legal system? Have you done that? No, not yet. Oh, really? You haven't done that? Well, you have. The one thing is, of course, to give effect to what was intended by the legislature as reflected by the words in the provisions. That is the function of the courts interpreting the law. Of course, as I had said, if the words used are very simple, very clear, it doesn't mean that they don't need interpretation. It is then we say is the interpretation will be so simple that the courts may be regarding itself as just at the stage of implementing. You don't really, but you don't have to go through a very formal process, but in actual fact, that's being done. It has to be done. Yeah. Right. And as I had just said, the most important rule nowadays, or most commonly used rules, is what we call the last rule here, the purposive approach. And the purposive approach has been described as the modern version of the mischief rule. Can somebody tell us what is mischief rule? Mischief rule. No, I'm not getting any response. Mischief. In the context of a public policy, when we say what is mischief in that context, public policy, or in lawmaking, it is the thing that, or a situation, or a behavior that requires regulation by the law for achieving a certain aim, either for restricting that or for facilitating that, or what? Mischief. And it sounds like a very old word, and in fact there's not much difference when you use the word mischief, the word purpose, i.e. why do you have to make this law? The answer will contain the mischief. And this has been increasingly used by the courts, and effectively, practically, it means considering both the wording of the law and the purpose of making the law. And at this point, I'd like you to also look at Section 19 of the Basic Law. Section 19 of the Interpretation and General Clauses Ordinance. Oh. And then can you see that? The screen I'm sharing with you, Section 19. Can you see that? Yes, thank you. An ordinance shall be deemed to be remedial and shall receive such fair, large, and liberal construction and interpretation as will best ensure the attainment of the object of the ordinance according to its true intent, meaning, and spirit. Section 19 is a statutory provision in the Interpretation and General Clauses Ordinance. It is the general principles of interpretation, and these general principles are binding on the courts when they are performing the function of interpreting a law. Of course, Section 19 itself requires interpretation. This is where it is interesting, right? Section 19 was considered by the Court of Final Appeal in the case of David Chow, and Permanent Judge Bukhari explained how this provision should be understood and applied. And in short, this reflects all the aspects of a purposive approach. Now, the question is, this applies to the interpretation of an ordinance. Is basic law an ordinance? Is basic law an ordinance? No, correct? So that's correct. So in legal terms, this does not apply when the court is interpreting the basic law. The court will instead has to apply what is said in the case of Garling. Can you see Garling here? Are we returning to the PPTs? Yes, good. Garling says the purpose. First of all, indeed, the verse is what the court has said was you should not be rigid, and you should adopt a purposive approach, meaning that you have to look at the purpose of the instrument, which is the Hong Kong Basic Law, and its relevant provisions, as well as the language of its text in the light of the context. So, is the purpose of the instrument, and what is the purpose of the instrument as a whole, as far as the basic law is concerned? Where can we find it? Well, it can be found in the preamble to the Hong Kong Basic Law. And the court may also be assisted when interpreting the basic law. Where it is relevant, it may also look at contemporary documents or historical documents that led to the enactment of that law. And in the appropriate case, the joint declaration may be referred to. And after having identified the purpose of the instrument, that is the basic law, and then you go to the relevant provision and you look at the language in the light of the context. Now, what does it mean by context? Well, it basically means everything relevant. And judges sometimes say that in law, or in the interpretation of law, context is everything. You have to look at, when you're interpreting any law, the context is everything. And in that case, in that sense, context must include the purpose that the law was enacted for which it was enacted. So remember, that is the purposive approach. Let's take a break, and then we'll carry on looking at the rest of this topic. And let's take a 15-minute break. I wouldn't mind, there may be other classmates who are in your similar situation, but could you elaborate on what you had written? Now I'm going to turn on your microphone, and maybe it's better if you are expressing yourself orally. Could you let us know or tell us what is the problem that you are having? Jen Hongman, do you have your mic on? Do you want? Is Mr. Zhang? Can you hear me? Right. I'll move on. Thank you. Right. Purposive approach. Right. The next we want to do is to make reference to the Zhang Fengyun case. The Zhang Fengyun case. Zhang Fengyun case itself is both important and significant, obviously, for the result of the case, and also, the legal principles of interpretation of the basic law that should apply. The facts of the Zhang Fengyun case, let me put that to you, or make use of some. I'll make use of a ready-made material prepared by the government. You see that shared screen? Did you manage to see that? Good. Now, the facts are very, very simple. The applicant, Zhang Fengyun, was a Chinese citizen who was born in Hong Kong, while his parents were in Hong Kong lawfully with a two-way permit from the mainland on a visit. His parents were not residents of Hong Kong, permanent or otherwise, and Zhang Fengyun claimed to be a permanent resident of Hong Kong SAR and to have the right to abode pursuant to Article 24(2)(1) of the Basic Law. 24(2)(1), unless you remember it, you remember it, or otherwise it's better if you could turn to Article 24(2)(1). It says, the permanent residents of Hong Kong SAR shall be 1. Chinese citizens born in Hong Kong before or after the establishment of the Hong Kong SAR. So Zhang Fongyun was claiming that under the Chinese nationality law, he was born as a Chinese citizen, and because the place he was born was Hong Kong SAR, therefore he was entitled, he falls within the description of Article 24(2)(1), the provision I just read. The CFI held that the requirement in the Immigration Ordinance that either parent had to be settled or had the right of abode in Hong Kong at the time of birth of the claimant or at any later time derogated from the rights conferred by Article 24(2)(1). There was no ambiguity and no doubt as to the legal meaning of the article. This is according to the Court of First Instance, which conferred the status of permanent residence on Chinese citizens who had been born in Hong Kong. It was therefore declared that Zhang Fongyun, the child, was a permanent resident of and had the right of abode in the Hong Kong SAR. So basically the court, that was in December 1999, said, well, the words are quite clear. There's no ambiguity and no doubt the legal meaning must be the meaning of the words. It didn't say that the parents had to be settled or had the right to abode in Hong Kong when the child was born. So that, with that finding, Zhang Fongyun was declared, well, first of all, the law in the Immigration Ordinance was declared to be in contravention with the Basic Law, and therefore no effect, and Zhang Fongyun can apply to the Director of Immigration for confirmation of his status. But the Director of Immigration appealed to the CA, and the Court of Appeal affirmed the original decision and similarly considered that the article was concise and clear. And before Zhang Fongyun, in the case of after the case of Garling, the Standing Committee of National People's Congress did make an interpretation, but that interpretation was not specifically on this article, but also on Article 22. So the Court of Appeal said that it did not specifically address this 24(2)(1) article, and the figures do not support that there will be a mass influx of immigrants. This issue of mass influx was used as in Garling's case, was to support the claim that it was not the intention of the Basic Law to allow such large number of people from the mainland to enter Hong Kong, which will overwhelm all the public services, including hospitals, education, transport, housing, that Hong Kong government was able to provide. That argument did not find favor of the judges, and as a result, the Director of Immigration appealed further to the Court of Final Appeal. Court of Final Appeal made a decision a year later, 2001, July 20, and further confirmed the decisions below. So Zhang Fengyun was continued to be able to enjoy his status as Hong Kong permanent resident, and therefore, after Zhang Fengyun's case, if you remember, Hong Kong was facing a pressure of influx of mainland women, pregnant ladies who came to Hong Kong to deliver babies, and they were called the Xiong Fei because neither the father nor the mother is a Hong Kong PR, permanent resident, and but under the Basic Law 2421, a child born to these parents will acquire the status of permanent resident automatically. That was considered as a problem, and it was eventually resolved as of today by administrative measures, discouraging and even preventing people entering pregnant mothers, pregnant mothers to enter Hong Kong, make it more difficult for them. Zhang Fengyun's case, as I said, the significance, of course, lies with also in addition to the result of it. It also had propound certain general principles. The first and foremost one was important one was the principle that the court said in interpreting the Basic Law, courts in Hong Kong should follow the common law principles. Secondly, the interpretation, the Standing Committee's interpretation of the Basic Law are only binding if that interpretation concern issues that are being litigated before the court. And since the interpretation rendered in 1999 did not cover Article 2421, that interpretation could not apply to Hong Kong. I mean, to the case. That just did not follow that. So that's Zhang Fengyun, right? So remember the case. It's a case of significance, and you should read it. Both you should understand the facts and the principles that it has developed, the principles of interpretation that it has developed. And you will see that when you read the judgment, a lot of emphasis is put on the meaning of words. After all, the main emphasis is on wording. If a wording is not ambiguous, i.e. there's only one possible meaning, the court will always follow this meaning. If the wording of the law causes problem, then under the separation of power principle, it is for the legislature and not the courts to change or to amend the law in order to address those problems. In some way, of course, the courts may not be as inflexible as it suggests, or as pedantic as it suggests. There are situations where, if justice demands, in the interest of justice, the courts may adopt an interpretation that might even strain its meaning but achieve the purpose, or a technique of reading up or reading down the law, on the presumption that the intention of the legislature would be to comply with the law, or would be to comply with international obligations that the place is subject to. So the causing problem, in a way, it really sometimes depends on what the problem is. However, if the problem is such that the court considered that if they did or apply any of that sort of skill in interpreting the law, it might usurp the function of the legislature, then the court will be slow and will be reluctant to exercise that power. In the Zhang Fengyun case, you see that 24-1 grants all Chinese children born in Hong Kong the right to a vote. And just on the plain wording, it doesn't require parents to have any connection with Hong Kong. But the immigration ordinance has the schedule set out the detailed requirements which require the parents to have been allowed to live in Hong Kong. So that was something add-on that the Basic Law did not provide, and therefore on that basis the courts had found against the Director of Immigration. So the result was the child was allowed to continue to stay. And just repeating what I said earlier, an important quotation is when the language of the provision is considered in the light of its context and purpose, the meaning is not ambiguous. That is, it is not reasonably capable of sustaining competing alternative interpretations. There could only be one meaning. That is what the court has said. Only one meaning. So the practical effect, as I said, the courts did not find it there is permissible, did not find it permissible for them to even consider the practical problems that it might lead to if they were to find in favor of Zhang Fengyun. As a matter of fact, there have been a large influx of mainland mothers wanting to give birth in Hong Kong. So clearly, this is where there was a case before us illustrating that the courts are really very strict, even when being addressed by government, that their decision, if considered otherwise, would cause big problems. If subsequent to well, this brings in a very interesting question of the legal effect of the decision, and also the need, the need or otherwise, to amend the law. let's start from the very basic. The system that we have, the legal system that we have, is the common law system. Under the common law, a court decision is only binding on its parties. It doesn't have the power to make an order against government or indeed the legislature. It can only make a decision to decide whether the plaintiff is right or the defendant is right, or the applicant is right, or whatever order that the court consider to have a jurisdiction to make. And in the challenges against a piece of legislation, including Schedule 1 of the Immigration Ordinance, the court can only make a declaration declaring the provision to be in contravention with the Basic Law or not. And then, following from that declaration, depending on what that is, it will make an order in the context of the case before the court. It will not, and it cannot make an order against the Legislative Council and say, Legislative Council, amend the law. No, it doesn't have that power. So the Legislative Council can actually disagree with the decision made by the court. And under the common law system, what is written in written law will prevail over legal principles decided by cases or established by cases. So, in theory, the legislature can ignore, not can ignore, is not obliged to amend the law subsequent to a finding that the written law contravenes the Basic Law. However, under the common law doctrine of precedence, if there was a decision made by, in this case, if it was a top court, CFA, made such a decision, the legal principle relied upon or declared by the court in that decision becomes binding on all lower courts in subsequent cases. So you can imagine the practical legal situation is, even if the legislature did not amend the relevant statute, the legal effect that this statute was intended to have will not be given effect, will not be recognized, because courts will follow previous decisions. So that explains how the various principles interact, and in practice, unless the government took great exception to a decision made by the court, they would, at an appropriate time, amend or propose to amend the law for it to be consistent with the decisions made by the courts. Situations where the government took great exceptions had occurred, not in Hong Kong, but in UK, where House of Lords decisions were simply not giving, were effectively have their effect neutralized by a contradictory written law enacted by the legislature, by the parliaments. But that is a rarity, an exception than the rule, more an exception than a rule. Does that answer your question, Jia Yi? No effect? Not ordinance. It is that particular provision. That particular provision. I think if you look at it now, I think it was amended subsequently. We can let me just double check. I think it was amended subsequently. It was. You see, right. You see there? This is what I'm showing you is the text of first schedule of the immigration ordinance, and section 2. Now you can see it was then amended in 2002, and is now worded exactly in the same manner as what the basic law is providing. There's no additional requirement that the parents had to be resident of a PR of Hong Kong. It's got it? You can check against that. Good. Okay. All right. During those few years, there are quite a large number of right to a vote cases, and the next one that we would like you to look at is the case of Tam and Tam Ma Yin. The facts are of course important, but from our point of view now, the principle that we should actually remember. This is in relation to Article 24.2.3. 24.2.3 is provided as follows. It says, persons of Chinese nationality born outside Hong Kong, of those residents listed in categories 1 and 2. 1 and 2, we just had Zhang Pongyun. He was class category 1 because he was born in Hong Kong. Category 2, Chinese citizens who have ordinarily resided in Hong Kong for a continuous period of not less than 7 years before or after the establishment of the Hong Kong SAR. These are people who have acquired permanent residence through living here for 7 or more years, and they themselves are Chinese citizens. And this third category refers to their children who are born outside Hong Kong. Under nationality law, children born to Chinese nationals, no matter where they're born, they are Chinese, or they acquire Chinese nationality by birth. So this wording, the question was whether that covered children adopted outside Hong Kong and not covered by the answer, fairly straightforward, is not covered. Now, if you ask, is it a must? Well, I mean, the court already decided that they don't cover. But in some circumstance, there might be room for an expansive reading of the word born. Right? The court said, as quoted in the next page, the next slide, it's only when the wording were ambiguous that the court would be indeed likely, and sometimes we say required, to lean in favor of an interpretation that adopted children are included. But in this case, the language is simply incapable of sustaining an interpretation that adopted children are included. So, despite all the sympathies that people had expressed, there was no room for court to give any interpretation different from the one that had been given. So the consequence is that people in similar situation, and this is how common law works, not each and every one has to go to court, but only some of those, and during that time, the government and including the Department of Legal Aid had selected some representative cases as the litigant whose case were put before the court for the decision. And it was accepted that it was a fair way of dealing with the problem or with the issues in terms of the efficient use of public resources. Because these applicants, most if not all of them, were represented by lawyers engaged by legal aid department, which means that they have to pay minimum cost, and the bulk of it was taken care of by public funds. So the law being, so the legal situation is such that the applicant, even having grown up in Hong Kong and adopted by the parents, cannot have the right of a vote, relying on that provision. Lucky or fortunate from her point of view, there is a provision in the immigration ordinance which gives the discretion to the commissioner to allow a person to stay in Hong Kong without conditions, and if that person have been able to live in Hong Kong long enough, 7 years, and that will qualify the person to becoming a permanent resident. So eventually, as this case has shown, there was sympathy, and the Director of Immigration exercised discretion and had allowed her to stay on that basis, not because of the basic law. What about on the mainland? What about in China? Well, in China, all the powers vest with the supreme organ of power, which is the National People's Congress. And its powers and functions are stipulated in the Constitution. The body itself, the National People's Congress, doesn't exercise the power of interpreting the law, but it is the Standing Committee of the National People's Congress, which under the Constitution is given that very power. However, that is the formal position. In the day-to-day operation within the system, you will find that there are two types, or sometimes they say three, and sometimes even more, interpretations given by bodies such as the Supreme Court, Supreme People's Court, and Supreme People's Procuratorate. They issue formal interpretations. And in fact, indeed, these powers are recognized in the Law on Legislation. Law on Legislation, Article 104. Law on Legislation is 立法法. And under that provision, any interpretation rendered has to be reported to the National People's Congress Standing Committee within 30 days. So that is the system that operates on the mainland. There are no, well, because of the nature of the common law system, there's no, first of all, there's no power. A court does not have the power to interpret law. The court's powers are to apply the law. You may ask, what's the difference between applying the law and interpreting the law? Isn't it logical to say that when one is applying the law, that person, and here the judge, must have interpreted or must have given certain meaning to the law before they apply the law, and it is the meaning of the law that the judge gave becomes the effect of the law. So isn't it just a difference of words, but not in substance? When you say judges in the common law system interpret law and judges in the mainland system only apply the law, doesn't it mean the same thing? Well, this is a subject for research, for thesis, but in light of all the reforms that are being introduced on the mainland, one actually start thinking whether on the mainland, despite the official position that there's no doctrine of precedence, the fact is that judges incline and tend to follow previous decisions, and also the Supreme People's Court had published some sample decisions for the guidance of judges, and that, on the face of it, is another form of binding precedent. So it's really difficult to tell about the difference, whether there is a doctrine of precedent, whether it is important to consider how courts interpret the law without judicial precedence, or let me put it another way: how courts apply the law when there's no doctrine of judicial precedence on the mainland. I think this is more academic than real. But in practice, what I would like to impress upon you is that when it comes to interpreting the law, in China, mainland China, words, the meaning of words do not normally put, in as the first place. And the most important factor seems to be the original intention in making the law. Now, this is, ironically, one of the justifications for giving the power to interpret the law to the lawmaking body, to the Standing Committee of National People's Congress. But at the same time, in common law system, it is that also that very system, that very justification, which puts the power to interpret in the courts rather than the lawmaking body. Because the argument goes this way, that because lawmakers die, and so for archaic laws, if we should rely on original intention, all those bodies, literally, holding those intention, would no longer be with us. They would have died long time ago. And how do you ascertain that original intention? The most you could do, of course, if there was accurate record of what was considered, then arguably such intention could be discerned from those records. And this is what we today, when we are applying this purposive approach interpretation, that every so often involves a research of archived materials to dig out records that were kept during the process of lawmaking. And because of the fundamental difference in mindset and in philosophy, you can see that interpretation can be used to supplement laws on the mainland, fully justified within that system, rather than going through a formal lawmaking process which will take months and months, if not years, for a lot of reasons, one of which is that National People's Congress do not sit. It doesn't sit more than, normally only sit once a year. And therefore, the interpretation of law to achieve the purpose of adding to or changing words of the law does happen. But of course, without going deeper into the mechanism, looking at the actual mechanism of seeing how it works, I wouldn't put any value judgment on this to say whether it's better or worse than what we have. Indeed, if you go to reading up current reports and literature on the subject on the mainland, it is also a subject which has received a lot of attention in the context of considering how and the manner of making these interpretations should be fair and consistent, and would give effect to the national policy now as reflected in the Constitution, that the governance should adhere to the principle of rule of law. this rule of law concept or doctrine having now reflected in the Constitution is an object of great significance now on the mainland. But back to Hong Kong, what we do see is that there is clear conflict because of the underlying fundamental principles and philosophy between the two systems. These conflicts need no further elaboration or explanation, but what we have done is articulating them in the following words. So, what are the conflicts? First, in Hong Kong, it is for the courts to interpret laws. And when they interpret laws, the focus is on the wording of the law and in accordance with established principles. In accordance with established principles, of course, is a reflection of the doctrine of precedence. Point 3, if the wording needs to be changed, it is a matter for the legislature. This again reflects the concept of separation of power in the common law system. In China, it is the body which made the law which is given the power to interpret it. Now, we have to be careful here because the actual body is the standing committee of the National People's Congress. So, for a law such as a basic law, which is, the basic law of the Hong Kong Basic Law, which is a basic law, small letter B, small letter L, that is the NPC, the National People's Congress, does not interpret those laws under the Constitution. It is for its standing committee. It seems that when they interpret the law, their focus is on the original intention of the law, of that particular law. And if wordings need to be changed, they can do it. They can through interpretation. They can do that through interpretation. So are we clear on these concepts? The concepts of amendment, the concept of interpretation, how these two actually differ in Hong Kong, and how they differ on the mainland, and more importantly, when it comes to interpretation of the Hong Kong Basic Law, how does it work? How does it work? This is what we want you to be able to understand. Are there any questions on this one? Right. So ask you the next actually is asking you the question. Which system in Hong Kong? Basic law. Asking the question before dealing it, as presented on the slide. The two questions that we have to be able to answer first. The Hong Kong Basic Law. Is it a law? Is it a Chinese national law, or is it a Hong Kong law? Is it Chinese law or is it Hong Kong law? Both. Well, that may not be a wrong answer, no, but I think you need some elaboration. Maybe the question I asked, I didn't ask the question properly. If the question was who made the Hong Kong Basic Law, or which body made the Hong Kong Basic Law, then what would be the answer? Yeah, MPC, right? MPC. So it is Chinese national law, right? Yes, the two dimensions. That's right. And this takes us back to where we had started. How we started, looking at the various dimensions that we should look at from which we should look at the Hong Kong Basic Law. And in the case of David Ma, the judges. I mean, it was very early days of the Basic Law. Reminded us, or actually gave very enlightened us as to how to look at this piece of law. So it depends on which dimension we are looking at, and it is a Chinese national law for sure, but it actually is having effect in the common law system. And you see the interface, and indeed when we come to the interpretation point, it becomes very clear that there appears to be clear conflict. That is on our last slide, and for it to operate without too much friction, we need some form of compromise. So the first two bullet points, we say under one country, two systems, Hong Kong follows common law. But Hong Kong Basic Law is a national law made under the Chinese legal system. So the result has to be a compromise, and a compromise that is reflected in the mechanism devised in Article 158. So we have both systems of interpretation being used. The first system is reflected, given in Article 158.1. In strict legal terms, this reference is unnecessary. The provision says the power of interpretation of this law shall be vested in the Standing Committee of the National People's Congress. It's unnecessary because in Article 67 of the Chinese Constitution, it has already been so provided. But for completeness, it's placed here as the first subsection of 158. And then the second provision, 158(2), provides that the Standing Committee of the National People's Congress shall authorize the courts of the Hong Kong Special Administrative Region to interpret on their own, in adjudicating cases, the provisions of this law, the Basic Law, which are within the limits of the autonomy of the region. So second sentence contains an authorization. But this authorization is with limits, and the limits are determined by the scope of autonomy, the limits of autonomy. Two aspects that you can see from this provision. One, it is not an inherent power. This is not common law power that the courts have. Courts have the power to interpret law as part of the common law by virtue of their position. But that is only in relation to laws made by Hong Kong SAR. Laws made by mainland China, although they are law, they are written law, having effect in Hong Kong, but they are not automatically be subject to the power of interpretation. It is done through authorization, delegation. It authorizes. The National People's Congress, being the supreme organ of power, authorizes the court to interpret the Basic Law. There's no concept of separation of power in the Chinese Constitution. All the powers, be it executive, legislative, or judiciary, all aspects of governance, the powers to govern, lies with the National People's Congress, either exercising them directly or in the supervisory capacity. And that's why there are senior government officials. The appointment is by way of election or endorsement by the National People's Congress. Judges or the judiciary is subject to supervision of NPC, and against the provision that the exercise of power to adjudicate has to be without interference, and yet the courts are subject to the supervision of the National People's Congress. So 1582 is delegation, an authorization. Now what it comes to tricky point is, so if you authorize the Hong Kong courts to interpret the Basic Law, what kind of principles should the courts apply and follow? Should they be common law principles, or should they be principles applied on the mainland? In very brief and crude terms, we say common law courts, the focus is on the words, the meaning of words. On the mainland, the focus is on the intention, or intention of the lawmaker. Then, when it comes to interpreting the Basic Law, what principles should the Hong Kong courts follow? The common law principles or the principle on the mainland? Which should be it? Do you have an answer? Follow the intention. How do we know? The common law. I think the direct answer or simple answer is common law principles, and this was actually so propounded, so declared by the Court of Final Appeal in the case of Zhang Fengyun. In the case of Zhang Fengyun. This becomes a little bit complicated. A little bit complicated. Because not in the context of the basic law, but in the context of the national security law. Yes, Chen, you are right. If MPC has issue interpretation, then Hong Kong courts need to follow. We will look at that again, although I mentioned it briefly earlier, but we'll look at it again on this particular point next time when we come back. But here I would just make a quick reference to Article 65 of the Article 65. Let me put it in. Article 65 of the NSL, the National Security Law. The power of interpretation of this law shall be vested in the Standing Committee of the National People's Congress. Now, in the National Security Law of Hong Kong Special SAR in safeguarding national security, the law in safeguarding national security doesn't seem to have a provision that that authorizes the Hong Kong courts to interpret the national security law. Indeed, it has a provision which says in 62, which says this law shall prevail where provisions of the local laws are inconsistent with this law. So this is seem to have provided a different system, a system different from that under the Hong Kong Basic Law. And if you notice, and that new Chief Justice seemed to have said that publicly that the Hong Kong courts had the experience of dealing with these challenges, and he says "Sanjing Bajin." So we shall see how these may be rationalized in a case before the courts in Hong Kong. Of course, this is the nature of a common law system. We don't really know until about how issues or how issues we perceive now. We thought there might be difficult issues or difference of opinion. How those will be resolved until there is a case before the court. Courts in the common law system does not provide advisory opinion. It doesn't tell you, or it doesn't really come in until there's a real dispute, a real controversy on a certain issue, and it is then at that moment that the courts, when the parties invoke proceedings, that they will be involved, but not before. Right. So you can see our last bullet point, which I think just expressed our opinion that it inevitably will lead to problems since the two systems are so different. Of course, we are not saying that it is not, problems in terms of in terms of saying that problems to be solved, to be resolved. These are not problems that cannot be resolved, because you can imagine the law cannot be allowed to sort of bog down just because of this apparent conflicts or apparent friction. Because you will appreciate at the end of the day, China being a unitary state, as it has kept on, officials kept on reminding people, including those outside of China, that there are legal means for them, for the central authorities to make or decide measures to address those issues. These measures, being called by various terms, decisions, if you like, those can already have the force of law, and so when we think that there are problems, the next is really how those problems can be or will be resolved. Right. Are there any questions so far up to this point? In answering the question that I just saw, I really cannot answer your question, because we are now at the level of learning that the lessons are a medium through which the basic information, or rather, I would suggest I describe this as knowledge, rather than information, will be imparted, but all in the context of the manual being, or on the assumption that you will have read the manual, and you will understand and digest the manual together with supplemental information that I provide at lectures, and indeed through our discussions, and that have been the mode of teaching and learning. Unfortunately, because of the way that we are now confined to doing this through online, without face-to-face, the incentive for live discussion was very much reduced. So I couldn't, and specifically on your question, it really depends on how you had pick up the knowledge and how you had digested. So I should think, as long as you focus on what we had discussed or what we had covered in the lessons, and also read the materials, the manual, you will have more than enough. You only have 2,000 words to write, I'm sure. So I wouldn't worry. So my advice is, if you have not started, you must do so as soon as possible. Don't wait until you thought you're ready. Just get on with it, and give you plenty of time to review it once, or at least once, or if not more, before you hand it in. Other questions, please? Right. So well, let's call it a day, and we shall meet next time, next Tuesday. Next Tuesday. Same time. Thank you. Thank you so much.